Good morning, everybody, and Happy New Year. Welcome to our first webinar of 2022. And today we're going to be looking at the HR year ahead. And we shall look at what to expect in 2022, ranging from employment legislation, case rulings, and what the main topics of interest and issues facing employers are likely to be. So as usual, we do like to introduce ourselves first for those of you who are new to our webinars. And for those of you who have not joined before, I'm Victoria Templeton, one of the HR knowledge managers here at HR Solutions, and I'm joined today by Sue Watson, our Head of Client Services, who will be supporting with the polls and also in our Q&A at the end of the webinar. We're also supported today by Rebecca Gormley, who shall be in the background to deal with any technical issues. Hopefully we should escape some of those. So, but just to let you know, we are on hand should anybody experience any technical problems. And because we have so many of you today, we've had to place you all on mute, but obviously, as always, we do want to hear any questions you may have. And so we will be taking questions at the end of the webinar, so please do let us know of any that you have, and you can do that by noting them in the question box that's available to you. So here's a quick guide just to show you how to do that, and you'll see that you have a GoToWebinar panel on your screen that should look something like this. So please type your question in the questions pane, and then we'll aim to read out and answer as many as we can at the end of the webinar. We do have several polls running through today's webinar as usual. So when you see this slide, then this is around letting you know that there's going to be a poll coming up. Now, for those of you that have not used polls before or attended our webinars, then please just do not be in full screen mode, because for some reason the polls don't operate on GoToWebinar in full screen mode. And so let us now look ahead at the HR year for 2022. And as I said a moment ago, we are going to be looking at the employment legislation for this year, as well as just several case rulings to look out for that we think are going to be key to employers. And then we'll finish off the webinar just looking at some of the key policy areas that we think businesses should be starting to look out for and perhaps work on in 2022. And as I said, we'll have some Q&As at the end. So before we get going, we just want to run a couple of polls. So I'm going to ask Sue just to run the first poll, which is all about whether you feel prepared for 2022 from a HR perspective.
Okay, I'll launch that poll for you.
Thank you.
I'll just leave that for a minute to give everybody a chance to vote. Nearly there, I think.
Yeah.
Okay, I'll close that poll.
Brilliant.
And I'll share the results with you. And there we go. So we've got 57% yes and 43 no. It's quite close.
What the results are.
And share the results. So very similar, actually.
Okay.
58% yes and 43 no.
Okay.
So again, some interesting things coming up that they are aware of, but you know, we do need to
Yeah.
take into account quite a lot that's going on and changing in April that will affect budgets, won't it?
Yeah, absolutely. So so thank you. So hopefully you'll take away quite a bit from this morning's session then to help you plan for the year ahead. So let's crack on then with the rest of the webinar. And on this slide, it's really just to summary at this point, just to let you know what the employment law timetable is for 2022. Those of you who are not familiar with employment legislation, then changes to legislation occurs generally twice a year in the April and October. And currently we have specific dates in place, pretty much with most taking effect in April. So this is sort of just a snapshot of what's going to be happening and what I'm going to be talking through this webinar with you. So there's a few financial implications here from those legislations. The first one to sort of let you know about is the gender pay report. So from the 30th of March, public sector organisations and 4th of April for private sector organisations, they must publish their gender pay gap reports. And those reports are to focus on the 12-month period starting from either the 31st of March for public sector or the 5th of April private sector. So we have that. That's one of our first things that we need to conform with. And then we move on to the 1st of April when we have the introduction of the Health and Social Care Act of 2008, Regulated Activities Amendment Coronavirus Number 2 Regulations 2022, which is a bit of a mouthful, but essentially this is the legislation that requires mandating of vaccines in the wider health and social care setting. So the purpose of this legislation, which I'm sure you'll all know, will be about reducing the spread of COVID-19 in that wider health and social care environment, including an individual's own home, to protect somebody who's receiving care, as well as protecting employees in the health and social care sector. So what it means is that from the 1st of April, it will become illegal for a setting operating in that health and social care sector that provides nursing or personal care in respect of a regulated activity to allow anyone in their premises who cannot evidence that they've been fully vaccinated against COVID, or where they are exempt from the regulations and they need to show that proof of the exemption. Now, this piece of legislation amends the current Health and Social Care Act of 2008 regulations of 2014, because they're currently in place for relating to the CQC registered care homes in England and businesses that operate within them. So you will probably have heard in the news that care homes up to now in England since November have had this requirement in place. So this Health and Social Care Act that's taken effect from the 1st of April 2022, it is going to cover settings such as GP surgeries, dentists, hospitals, community services even, and not just those working in a clinical role. It is likely to apply to roles such as receptionists, porters, cleaners. So it's really important that if you're operating a business that goes into these premises where they undertake regulated activities, then there will need to be that evidence of vaccination or proof of exemption. We are currently awaiting the operational guidance on how to implement the legislation, which they have indicated it is likely to be within over this week. And as such, we'll always obviously send our news bulletins out and update our templates on the knowledge base for everybody. But just wanted to let you know where we are with that. And then if we look now to the first piece of legislation that will have a financial implication, and that's national minimum wage. So there is going to be that increase, as there tends to usually be in the April. And so we've had it confirmed that the national minimum age will become £9.50 for those aged 23 years and above. And as you can see on the screen, there's other rates as well. So you're £9.18 for 21 to 23-year-olds, £6.83 if you're aged 18 to 20. And £4.81 now applies to if you're 16 to 17 years old, as well as apprentices. So if you haven't started budgeting from that perspective, then it's now worth looking at how those changes will impact on your finances. Moving on to Trade Union Act of 2016. Now, we are seeing changes to this legislation. They do want to reform it, and so from the 1st of April, it's going to bring in functions of the certification officer in line with other UK regulators, such as your pensions regulator, your financial reporting council, as well as the electoral commission. So what it actually means is that those who are members of a union can be reassured that their union will uphold the high standards, as well as allowing the certification officer the ability to respond to third-party complaints when a union or employer association may have breached its statutory duties. So this is more about giving that assurances to a member of that union that they are going to be in a union that operates those very high standards, just as we expect, as I said, in those other regulators such as your pensions and your financial reporting council. So we now move on to the statutory rates again. So from a financial budgeting perspective, this is going to be important. And we are going to see an increase to statutory sick pay. So it's expected that the usual annual uplift to this SSP will be implemented, taking the weekly rate to £99.35. At the moment, it's £96.35. We then have the annual uplift to the statutory redundancy pay as well, and it's expected that the statutory rate of pay used to calculate a week's redundancy will be increased from the weekly cap of £544. But at this point, we don't know the exact amount. They've committed to making the announcement in February. So we'll wait that news, and again, as and when that comes out, we'll make an announcement on our website. And then there are other statutory rates, as you know, so things like your statutory adoption pay, statutory maternity pay, paternity, shared parental pay, parental bereavement pay, all of these statutory family-friendly entitlements are going to be increased, where they'll change from the £151.97 per week to the £156.66 each week. And then a major introduction is the national insurance increase, and we're hearing a lot about it obviously at the moment in the news, because it's just one element that we need to be mindful of in terms of the impact on employees' finances. So this follows the government's announcement, I think back in September, where they introduced a new health and social care levy. And so what we're seeing is that we're going to have changes to the national insurance contributions from the 6th of April this year. How it will work is that this increase to your national insurance contributions will be temporary at the moment. So it will increase by 1.25% to the main and additional rates of Class 1A and B and Class 4 for self-employed. There is an exception in that it won't apply this year for those employees who are over the state pension age. And these additional funds of the 1.25% for each employee, employer and the self-employed, those funds will go towards contributing towards the running of the NHS and equivalent bodies. Now, I said that these are temporary and they will run until April 2023. And at which point there will become a new identifiable health and social care levy that can operate this 1.25% collection, because at the moment the systems and technology aren't in place to manage it from this April, so they've got to make sure all the systems are ready for next April. So what will happen in April 2023 is that the employee, and employer and the self-employed, their contributions will come directly from this levy rather than the national insurance contributions. And so in April next year, 2023, NICs will revert back to the 2021-22 levels. At the same time, the introduction of the new levy processing those additional funds. So I think from a what we're saying is that the financial deductions are happening now and they're going to continue, but how it's managed for an employer will change. So it's important that your payroll teams are aware that at the moment for the year, it will be through your NIC's collection, and then from April 2023, there'll be a separate standalone health and social care levy to operate the collection of those funds. And then finally, we must not forget that we'll see changes to UK bank holidays this year as well. So we're starting to hear more in the news because there's been an announcement about how we're going to plan to celebrate the Queen's Platinum Jubilee. So we're going to see the spring bank holiday, which is the last one in May. That's going to be moved to Thursday, the 2nd of June. And then we're going to be offered an additional bank holiday for 2022 only. And this is going to be Friday, the 3rd of June. And as I said, these changes are made specifically to celebrate the Queen's Platinum Jubilee. Now, it's going to be essential for employers to check the employment contracts, because even though it's being offered, it may not necessarily be a legal entitlement for that employee to have that day off. So you really need to go and look at your employment contract, because this will determine whether that employee is entitled to the additional bank holiday of the 3rd of June. And then we move on to this slide, really, and this is about letting you know of other areas of employment law changes, but we don't yet have a date. It could possibly be 2022, who knows, but and some of these you're probably already familiar or heard of. So I just want to sort of give you a run through here as well. So the first one is the Employment Bill, and this is probably one you have heard of. Now, what we're expecting to see as part of the Employment Bill is a new body to enforce national minimum wage breaches and modern slavery. It will give workers in the hospitality sector the right to receive tips in full. It will allow workers the right to request a more predictable contract of employment, and it will also extend current rights, legal rights that are already in place for pregnant employees. So it's looking at extending employment protection from the point the employee informs the employer their pregnancy to 6 months after their period of maternity leave. Now, there's also a new entitlement to neonatal leave, and that's about providing employees up to 12 weeks paid time off to support when a baby is born either prematurely or is admitted to hospital in their first 4 weeks of life. And there's also going to be a new right to 1 week's unpaid leave for carers, and the right to request flexible working from day one of employment is also put through as part of this bill. So we'll wait to see how that develops and evolves, and when any of the changes come in. And as usual, we'll produce updates and news alerts around that. We also are going to see potentially changes to do with the Police, Crime, Sentencing and Courts Bill. So this is about looking at reducing the time for certain convictions to be spent. So it would mean that for certain convictions, they're not automatically disclosed on employment checks. And so what we're likely to see is that sentences of up to 1 year would become spent after 12 months, where there has been no reoffending. Sentences of 1 to 4 years will be spent after 4 years with no further reoffending. And then those sentences of over 4 years will not need to be automatically disclosed, where there's been no reoffending, where there's been a period of rehabilitation of 7 years. These changes to the Sentencing and Courts Bill will not apply to convictions that relate to things like your serious sexual convictions, violent or terrorist offences, when the sentence given was 4 years or more. We then also have a professional qualifications bill, and that's about introducing a new framework for recognising qualifications from overseas. So it's particularly aimed at those professions such as those in medicine, so your nursing, teaching, and it's about ensuring transparency around the entry and practice of those professions. We also have the Public Sector Exit Payments Bill, and that's around introducing a clawback that will prevent some public sector employees from keeping any exit payments when they return quickly to the same area of employment. And then the final two are to do with your Sunday trading, so protection for shop workers, and it's about bringing in further duties on employers to notify employees of their rights about working on Sundays, and it will also extend the rights of shop workers to opt out of Sunday working on the grounds of religious or family grounds when it comes to working additional hours that are over and above the contractual hours, because at the moment that part is missing. And then finally, the Bill of Rights. And again, this is probably one that's been in the news. It's been sort of on the radar for some years, and it was actually, it's about replacing the Human Rights Act of 1998. As I say, it's been on the horizon for some time, but it was put on hold until after Brexit. But we are starting to hear more in the news again about the Justice Secretary is starting to look at this Bill of Rights again. So it'll be interesting to see how that develops. So we're now going to move on to the section that just highlights 3 important case rulings that we anticipate are going to be, well, they will be coming through in 2022, but are likely to impact employers. But before we move on to looking at those 3 cases, I just wanted to run a quick couple of polls first of all. So Sue, if I could kindly ask you to set up the first poll.
First one?
Yeah, and it's about, do you employ workers on irregular hours or people who work only part a year for your organisation?
Give it another few seconds.
Okay.
Okay, most people have voted now, so we will close that poll and I'll share the results.
Yeah.
But quite a significant number again. Yeah. 53,
so,
47. Yeah.
Okay, so for the 53% of you, this is the next case is going to be particularly helpful or informative for you. Yeah, and for the 47% of you, if you do go on to employ people who work irregular hours or a part of a year, then again, the next case will be of interest. Okay, and we've got a second poll, and it is about, yeah, and it's a COVID poll. So have you had to deal with a situation over the last couple of years where somebody's refused to attend work or has walked out because of their worries over COVID?
Okay, I'll close that one and I'll share the results with you.
Well, our polls are fairly evenly split, aren't they? So yes, so quite a lot of you then, 56% of you have had to deal with a situation where somebody's refused to attend work or has walked out because of their worries. Okay, so yeah, we have a case ruling as well coming up that I'll run through that will be of interest to you. So thank you for that, Sue.
That's okay.
So back to the webinar, and the first case ruling is all to do with holiday, which we all just love, don't we? Holiday entitlements. So, and this is the Harper Trust versus Leslie Brazel and Unison. So, and many of you might have heard of it, but we have a ruling from the Supreme Court case coming up that we're waiting the outcome from. So it went to, I think, the Supreme Court in November, and it is a case that could have significant implications for businesses who manage holiday entitlement for those who work irregular hours or part of a year. Now, in this case, the Court of Appeal dealt with the question of whether a worker who only works part of a year should be entitled to the full annual statutory leave entitlement of 5.6 weeks. You know, i.e., so should somebody who works, say, 40 weeks in a year, can they still be entitled to a pro rata amount that's based on the 52 weeks rather than the 40? So this is the question at the centre of the case. And in the previous cases, the claimant had only been given holiday based on her actual working time, which was during term time only. The Harper Trust argued that they used a common formula to determine her holiday entitlement for the year, and that formula was the 12.07%, which many of you probably will be familiar with. Now, that historically has been something that we've been able to use until this case ruling. Now, the Harper Trust used this to calculate her entitlement for working 15 hours a week during term time only, not the 52 weeks. The Harper Trust argued that by calculating her hours over 52 weeks would give her favourable treatment compared to those who worked a full year. And in fact, they calculated that for the hours that she worked, if they had calculated it over 52 weeks, she would in fact be benefiting to holiday entitlement equivalent to 17.5%, which is significantly more than the annual 12.07% of her actual working time. However, despite this, the Employment Appeal Tribunal actually ruled that she should in fact receive holiday entitlement calculated across 52 weeks, rather than only for hours worked, over those term time weeks, meaning that the 12.07% formula was unlawful. And so that's why in the last probably couple of years, I want to say, don't quote me, but there was a change to how holidays should be calculated, because on the back of this case ruling, it basically said that formula that we've all been so familiar with using was unlawful and therefore should not be used. Now, they highlighted that to use the 12.07 formula would mean she suffered a detriment, which is against the law, as part-time employees must not suffer any detriment. Whereas to calculate holiday over a whole year of 52 weeks, whilst it would enhance her entitlement, there is actually nothing written within the regulations, the part-time workers or working time regulations, to say favourable treatment is not allowed. And that's why the courts ruled that she should have holiday based over the 52 weeks, which was that equivalent of 17.5%. Now, the Harper Trust appealed that judgment to the Supreme Court, and as I said, it went, I think, November, December. So it was heard at the end of last year, and we are awaiting the judgment to be announced. So this is a really, really significant case that will have implications for employers who employ workers on reduced irregular hours or term time, reduced weeks over the year. So it's a really important case. So watch this space. I'm sure once we get that ruling, we will be updating our knowledge base, and I'm sure we'll be sending some briefings out on our main website as well with conclusion to that. But it is going to be significant. So moving on to the second case, and that's in regards to Rogers versus Leeds Laser Cutting Limited, and this is the COVID case. So if you think back to that poll a moment ago, where all of you who've had to deal with situations where people have been worried about coming to work or refusing to come to work. So it is relevant because we still continue to work in the pandemic, and this employment appeal case is going to look at whether the original employment tribunal was correct in holding the view that general fears over COVID, rather than fears connected to the workplace itself, qualified as a serious and imminent threat for the purpose of the Section 100 of the Employment Rights Act of 96. So under this, the Employment Rights Act, an employee who's dismissed will be unfairly dismissed if the principal reason for the dismissal is where the circumstances of danger which the employee reasonably believed to be serious and imminent, and therefore led them to taking steps to protect themselves or other persons, so family members, by leaving the workplace or refusing to return to work. Now, the actual case is Mr. Rogers had been dismissed, although we're not clear how and what procedure was used, but nevertheless, he was dismissed and brought a claim for an unfair dismissal in connection with this section of the Employment Rights Act. Now, he believed he had protection from being subjected to any detriment or being dismissed for exercising his right to leave the workplace because he reasonably believed to be in serious and imminent danger, both for himself and his family members. Now, the tribunal at the time concluded that, or it's considered many facts that the employer had taken several steps to reduce the risk of transmission in the workplace. So, you know, we've all been doing our COVID risk assessments, we've all been trying to enforce that social distancing, mask wearing, checking temperatures before entry, etc., etc. You know, in this case, the employer took all reasonable steps to manage the reduce the transmission risk. And the tribunal also felt there was a lack of evidence by Mr. Rogers in showing that the workplace posed an imminent and serious risk. And so his claim was unsuccessful and he failed in his claim. The tribunal was satisfied that the employer did all it could to manage the COVID risks. The tribunal also ruled that the danger in the workplace was actually no more than in general society. And so, you know, for the obvious reasons of they put in all the measures in place. So the risks at work were no different to the risks out and about in general society. And so the tribunal did not feel that the circumstances relating to the walkout constituted circumstances of danger. Now, Mr. Rogers has appealed, and that's what we're waiting for now. So he's appealed that judgment. It's due to be heard on the 12th of April. And so it is going to consider whether the tribunal was correct to rule that the serious and imminent danger cannot be linked to general fears over COVID. So it's telling us, this original hearing, that the serious and imminent danger has to be specific to the workplace, not your general fears over COVID. So that's a really interesting case. We have started seeing cases come out during the pandemic and the implications for that. This is one that's obviously gone to appeal now, so it will be really interesting to see how it's testing that particular section of the Employment Rights Act, which is all about serious and imminent threat. And then finally, in terms of case rulings to look out for, this is the Smith versus Pimlico Plumbers, and you may know of this case as it's long-standing. It's been through several courts and it's been a high-profile case probably for over 10 years. And it's probably quite a complicated one in terms of, because there's been so many different rulings and back and forth between the courts. And there's two different stages to it. But this case centres around whether the original employment courts were correct not to uphold the claimant's claim for backdated holiday pay. Now, the original tribunal and the appeal tribunal held the view that the claimant had not filed his claim for backdated pay quickly enough. And under the existing rules, a claimant must claim for any missed pay within 3 months for each holiday period. Now, the claimant was arguing he was due backdated pay from 2005, so which amounted to around £74,000. But in terms of context to this case, what we need to also take on board is that back in 2018, Gary Smith won a claim at the Supreme Court against Pimlico Plumbers, which determined his employment status as worker rather than self-employed, and therefore, consequently, would be entitled to the holiday pay and other employment rights. And so in 2019, Mr. Smith claimed to the Employment Tribunal he was due that £74,000 in lost holiday pay because of his original 2008 Supreme Court ruling, which classed him as a worker. However, he lost that claim because he had not filed his claim for the backdated holiday pay quickly enough. And based on that case, Mr. Smith should have made his claim for missed pay within 3 months of each holiday pay, going back to 2005. So I said it's been going on for years and it's very complicated. And as you can gather, it has been going to and from, and it is not straightforward. But what's happened is Mr. Smith has now appealed the Employment Tribunal decision, arguing the original court had not correctly applied the law and that mistakenly concluded he had not been able to show it was not reasonably practicable for him to bring a claim within the 3-month limit. And he also argued that there had been another ruling in a separate case, which was King versus the Slash Windows Workshop, where somebody who was self-employed and found to have been a worker had successfully argued that they were entitled to pay during the 13 years that they'd worked, and therefore entitled to payment of untaken accrued holiday for 13 years. So that's his argument now at the Court of Appeal, using another case ruling to argue that actually, yes, he should be paid for the untaken holiday pay going back to 2005, which amounts to the £74,000 of unpaid holiday pay. Now, this case was heard at the Appeal Court on the 8th of December, and we are awaiting judgment. But the outcome of this case could have significant implications for employers when it comes to dealing with backdated holiday entitlement, and where perhaps you've got scenarios where people may be challenging their employment status. So whether they've perhaps thought they've been self-employed, but really are they actually workers? So I appreciate it's a very complicated case. There is a lot of history to it. It's gone back and forth, but in essence, this particular case could have implications. So as with all the others, we are keeping an eye out for the ruling, and when it does, we'll send a communication out and update our main website, etc. So that brings us on to just bringing the webinar to a close, where I'm just going to share with you some key policy areas that we think are going to be important and popular for 2022. And I guess the first one to talk about is corporate social responsibility, your CSR. There's a huge amount of focus and attention given to climate change and the environment. We're not just seeing employers starting to take a more active role in contributing to climate change, but also we're seeing employees are becoming more socially responsible and perhaps taking on board that when they join organisations. So we're expecting to see even more employees becoming more CSR conscious in 2022 through the development of policies, HR policies. We also think by having greener policies and creating greener working practices forms a key part of the employment relationship by enhancing the attractiveness of the employer brand and its values. And so having the right policies can be a huge selling point for attracting new candidates. And, given the current labour market where it's proving difficult to recruit, this is probably something that's worthwhile focusing on. So, for example, you could look at reviewing your organisation's commuting and business travel policies, looking at your health and safety practices and how they can focus on more efficient systems such as air conditioning, heating systems, or you may even look at your own procurement practices, so you consider who you're prepared to work with in terms of business to business. And there's also a greater focus, as you all know, on electric cars. So this is another key policy area we think employers are likely to look at, so that they can support employees either who already have electric cars personally, or how they can facilitate the management of company cars which are electric. We then move on to hybrid working, and this isn't necessarily something new, but we've started to see it from last year. And so it's probably the continuation of hybrid working. We know it's shown to be beneficial to both the organisation and employee. And for those employers, if not already, then they may wish to introduce a hybrid working policy so that there are clear rules around when it's appropriate, how it works, and the responsibility that comes with it on both sides. So we do see hybrid working continuing because, as I said, it's been so successful during the pandemic. Family friendly is another policy area to focus on. So we know that we're going to be having new legislation around neonatal leave and carers leave entitlement, that they're both on the horizon. So it's a good time now to review and update existing family friendly policies. You know, and traditionally organisations also have had a policy for each of the different areas of family leave. But we've seen an increase in employers moving towards having just the one policy that covers everything. So as well as reviewing the existing policies you have in place, think about too whether you wish to move to just one family-friendly policy, making it as easy, simple and clear for your employees as possible by just having all the information in one place. Because, you know, there are parts of the entitlements and rights that can sometimes get a little bit confusing or unclear, and just having it all in one place and doing a refresh will only help. We also think modern slavery is going to be a key focus for this year. So back in September, we saw the government announce plans for the reform of the Modern Slavery Act. And it looks as though the reform will look at introducing legislation that deals with 6 reporting areas: your organisation, structure and supply chains, policies relating to slavery and human trafficking, due diligence processes, looking at an organisation's effectiveness in preventing modern slavery and trafficking, as well as training of staff on human trafficking. So there is a lot coming up. It is on the horizon, and so this year I think will be one for looking at your modern slavery policy. And it is also due to be amended in terms of the legislation to mean that additional information will be required in modern slavery statements to improve clarity and enable scrutiny. And there will be eventually a new single reporting deadline for the 30th of September for all organisations and planned reforms to section 54 of the Act, I think it is, to be extended to public bodies that have a budget of 36 million. So even if the legislation doesn't get introduced this year, it's certainly worthwhile reviewing your existing policies and working practices in readiness for it. And then we move on to diversity inclusion, and for 2022 there's a possibility that we shall see new laws relating to sexual harassment. We're looking at new laws that will place a proactive and specific legal duty on employers to prevent sexual harassment at work, as well as possibly bringing back the laws on third-party harassment. Some of you might remember the Equality Act, where there used to be that clause where there was protection against harassment by third parties such as customers and other third parties. So we'll wait to see what happens on that. We're also going to be finding out the outcome of a recent consultation on the potential introduction of a disability reporting process, which could be either voluntary or compulsory. Now, the consultation process is still open. It closes on the 25th of March, so we've got some time yet before we get to hear the outcome of that conclusion, but there could be some changes on the horizon when it comes to the reporting of disability information. And then there's also a growing need within organisations for the introduction of guidance and support on transgender in the workplace. Now, it is an extremely sensitive and delicate area of employment, which does warrant training and upskilling, not just of line managers, but all staff as part of the usual diversity training. And furthermore, there's good reason for the implementation of a specific organisational policy for how you support and deal with transgender matters in the workplace. It is becoming more common in the workplace, and we require careful handling and an appropriate sensitive steps being put in place to help support everybody. So we see perhaps the need for having some standalone policy to support transgender in the workplace as well. So there's a lot on the horizon from a diversity and inclusion perspective. And then finally, we're likely to see some rules around our pay policies. So rules around gender pay gap reporting are being reviewed at the moment. But also from a pay point of view, I mentioned this probably at the outset, you know, with the financial pressures also affecting our employees, you know, with inflation, national insurance increases that we've talked about, then the impact of the pandemic and Brexit. Plus, we also have, you know, the current recruitment market is currently a candidates recruitment market. Employees need to think about their salary and reward packages to ensure that they remain competitive with a view to retaining their staff, retaining the skills and knowledge within the organisation, and avoid staff shortages. So I think recruitment and retraining costs, you know, need to be examined, and basically look at your overall pay policies to see how you can remain competitive within the current climate, especially with, as I said, the financial consequences for employees on the back of, you know, coming through the pandemic and the national insurance increases and the cost of living shooting up. So that brings me to an end in terms of the key policy areas for 2022, and we're going to now see if we've had any questions come in. So Sue, I'd like to invite you to ask any of the questions that may have come in.
Okay, so are you ready for this?
I think so.
There's quite a few questions around gender pay caps, so mainly around reporting requirements. So
Yeah.
just to clarify, for both private and public sector, the headcount, the minimum headcount before it's compulsory to report is 250.
Yeah.
So it's a headcount of 250.
Yeah.
There are obviously benefits of reporting with less than that, but it's only mandatory for 250
Yeah.
and above. And linked with that, somebody's asked about if it's the same headcount for the modern slavery. That's quite different. So the requirements to publish a modern slavery statement is if you are carrying on a business in the UK, but you have an annual turnover of 36 million. So those are the restrictions on that. There's a few other requirements as well, but that's the two key ones, that you are carrying out a business in the UK, supplying goods or services with an annual turnover of 36 million. So that they're two different requirements. The other one was asking about, is the national insurance increase applying to employers? Yes, that's going up by 1.5%. So 1.5 is for the employer, 1.5 for the employer, 1.25 for the employees.
Yeah.
So yeah, that's increasing too. Lots of very, very costly come April for employers. And then I think that covers the gender pay and the modern slavery. There's a question around, what if the contract states 28 days including bank holidays?
Then because it's not stipulating a number, it means that because bank holidays would include that 9th one of the 3rd of June. In that scenario,
if you close on that day, it dictates 9 days that are already counted for, so they have slightly less days to book themselves. Yeah.
So it's really crucial you look at your contracts to start working out any potential implications for, you know, for June.
And some employers are just allowing their employees to have them in addition anyway, as an additional day, as a kind of thank you for all the hard work over the last couple of years. So there is an element of, you know, deciding how you want to apply it, as well as, you know, as long as you comply with the minimum contractual requirement, you can be more generous if you wish, and make it clear it's an exception for this year only, for whatever reason you're making the exception. There's another interesting one regarding the public sector exit payments. This is an interesting one, because whether or not it'll actually come in this year is to be seen, because it started off in,
hasn't it?
2014 when they first put out the consultation on this. But they have capped it. There's a salary of 80,000 minimum, I think it is, isn't it? And it is returning to work within 12 months, or at least it was at the last stage they updated it. And there is a repayment plan that you can agree. There's lots of ifs, whats and buts around it, but as soon as we know more information, we will let everybody know. And it was anybody categorized as a public sector with by the Office of National Statistics, with some exemptions, would be classed as the department that you return to. So it was quite wide, but there were some restrictions as well. So that's one just to keep an eye on, because as I say, it's been, last year they implemented the cap, didn't they? And this year they're obviously looking still, they say it's still on their horizon to look at the exit payment. So watch this space for that one. So we've got linked to the bank holiday one. If somebody doesn't normally work on a Friday, do they receive the extra bank holiday?
So it's a non-working day, so they wouldn't.
No.
This is what, it can get confusing for people, because you hear in the news that everybody's, there's an extra bank holiday, and there's that assumption that, oh great, you get it, but actually you only get a day off if it's a contractual working day, or potentially, depending on your contract, if it's a contractual working day.
Yeah, and I guess it's still down to entitlement, isn't it? So if your contract states that you're entitled to 20 days plus bank holidays, and it's as open as that, that means their entitlement for this year is 29 days. And if they don't work Friday, so they're a part-time worker, then it's pro rata, their entitlement. But it just means they use it for another day's leave, not necessarily on that particular day, because they don't normally work. So again, it's all down to the contract as to how it's applied and the implications for staff. And another question relating to, who does CSR apply to? Which companies? I guess that's all companies, isn't it?
Oh, yeah. Every organisation can have a CSR policy. Yeah, in terms of your commitment to community, the social aspects, the environment.
Yeah, so I guess it's depending on what sector you're in. Some people, we have a number of clients ask us for a CSR policy because they need it for a bid, because a lot of bid packs require you to have an environmental policy or a CSR policy, or certain other kind of corporate level policies. So yeah, but it can be all sizes of organisations, but it is particularly in some sectors that it affects. And finally, the final question is around the Sunday trading. Would the opt-out apply to industries like manufacturing? Because obviously currently it relates to the shop workers, isn't it? So
it is the shop workers, isn't it?
So I'm not aware of it extending at the moment, but I would imagine it would be restricted to shop workers. But
the amendment that's focusing on is the additional hours element, isn't it? So it's just extending it from, instead of just your contractual hours, it's the additional hours that may be worked on a Sunday.
Yeah.
But the setting, there's no
change of the
setting or the scope of it. No. Yeah, thinking that through. Yeah.
Okay, I think that's all the questions that we have.
Oh, brilliant. Oh, great questions. Thank you, Sue.
Okay.
So I'll continue with just bringing the webinar to a close. So let's move on. So we do have one final poll actually before we just close the webinar down, and that's really to understand how we can help you in your business this year. If you would like us to contact you, then please let us know which of the following areas on this poll you'd like us to get in touch with you about. So our HR services, training and knowledge base, health and safety services and training, as well as our payroll. So please do let us know, and then we'll put the right person in contact with you.
Thank you. Just let that run. There's a few coming through at the moment. couple more seconds.
Okay.
Okay, I think we're there.
Thank you.
So
Brilliant.
I'll
Thank
close
you.
that now. Okay,
Yeah.
back over to you.
Thank you. And then, as usual, we just like to let you know about our training and webinar program we have coming up. So you'll see on this slide here that we offer ILM Level 3. It is online. It's a program that starts February and there's 6 sessions to it. And this is really aimed at those who have management responsibilities but no formal training. So it's ideal for your team leaders who'll be leading people through organisational change, budget cuts or other pressures. So if you do want to find out more, then please do get in touch. And then following on from that, we also offer the ILM Level 5 Award in Leadership and Management, again online, and this is a qualification designed for project managers, department heads and other middle managers. So it's ideal to develop your skills and experience, improve performance and prepare yourself for senior management responsibilities in your career. So this starts from March, running all the way through to May, and there's 8 sessions on the ILM Level 5. And then we also operate some HR management development courses, which clearly we don't have one in November and December as yet. So I don't know if Sue, you know, we've got any coming up for the new year, but we do offer CPD regulated courses for HR management and development.
Yes, there's a whole program up on the website for the January to April period. So yeah, have a look on our training course page, and
Yep.
it'll give you full details of everything that's available.
Okay, and we do operate health and safety training courses as well. We do have one on the, we had one on the 11th of January, that was the most recent, and as Sue says, please have a look at our main website for upcoming health and safety training courses. And so when it comes to the webinars that we run each month, then we've got several coming up for this first quarter. So the next one is going to be all to do with employee retention, about how it's key to success and what you can therefore do to improve it. We'll also then be looking in March around the importance of welfare meetings, so providing that advice and guidance for line managers. And then April is more technical in terms of it's about your disciplinary process and how to write legally compliant conduct allegations. And then we also are running our health and safety webinars. So we have an introduction into mental health first aid, which is coming up in January. And we also running the Why Do We Bother with Health and Safety, as well as an introduction to food safety. So it'd be great to have you join us on our webinars as usual. And then if you do want to stay in the loop and be amongst the first to be invited to our webinars, as well as receive our latest news, then please do sign up to our newsletter. The link is showing there. And a copy of the slides will be sent out, by the way, to everybody after the webinar. And so that concludes our webinar today. So if you do have any further questions, then please contact us on the information on the screen here, and we'll be more than happy to help and assist. And what we would like to ask is that we do appreciate everybody's feedback. So after the webinar, there'll be a short survey to capture your feedback, and we would really appreciate it because it really does help us build our webinar program and gives us that feedback to help work on improving our services to you. And that brings me to a close today. So thank you for joining us on our first webinar of 2022. Thank you to Sue for helping on the polls and questions. And thank you everybody for joining and taking time out of your busy diaries. We really appreciate it and hope to see you on the next webinar. Take care everybody, and thank you, Sue.